So the next topic we have here is the health insurance, and I want to go through a couple of things about health insurance. We start with the Ohio Revised Code, which is basically both parents are responsible for the health care of children. So any children that are subject to a child support order, basically. So in the event that parents get divorced, one possible way of addressing this health care issue is for both parents to secure, or at least one of the parents to secure, health insurance. However, it does not require that both parents provide coverage at the same time, but it does mean that if one party is providing coverage and loses that coverage, then the other parent is responsible for securing coverage for the children if it's available at a reasonable cost. If neither parent can secure coverage at a reasonable cost, both parties are responsible for the bills, basically. Currently, reasonable cost is defined as the contributed cost of private family health insurance to the person responsible for the health care of the children that does not exceed an amount equal to 5% of the annual gross income of that person. So basically, reasonable cost is considered to be any amount equal to that does not exceed 5% of that person's annual income. If the cost of health insurance does exceed 5%, then they're not going to be required to cover it, but they will still be required to pay those medical bills that result from the children, basically. If health insurance is available at a reasonable cost to one party, that party is going to be required, basically, to obtain it. And if health insurance is available at a reasonable cost to both parties, the parties basically can come to an agreement of who will provide it. If they can't come to an agreement of who will provide it, the court will likely order both parties to obtain coverage for the children. And that will reduce any out-of-pocket costs. If health insurance is not available to either party, both parties are ordered to obtain coverage if it becomes available at a reasonable cost, basically. And another thing that the court does in the event that neither party has health insurance is they have a cash medical support order, and the cash medical support is something new in Ohio. It hasn't been around for very long, only a couple of years. It's an amount of money that gets paid in addition to money that's paid in a child support order. So the obligor is the party paying the cash medical support. They only pay it if the children are not covered by health insurance. And one of two things happens with that money, with that extra money that they're paying. Number one, if the children are covered by CareSource or some form of government-funded health insurance, then that money actually goes to the state to pay for that coverage. And if the children are not on any CareSource or government-funded, it actually is going to the obligee, the person that they assume is paying for those health insurance costs, or not the insurance costs, but the health, the doctor's bills and anything related to health. And that's probably going to include, in most cases, doctor's bills, dentist bills, eye doctor, psychological issues, therapists. It's going to include the whole gamut. In all cases, the court, any extraordinary medical expenses between the parties, they're going to divide it between the parties one of two ways. They're either going to divide it equally, or it's possible they could divide it according to percentage of income. That's basically going to be a judge's or a magistrate's call in the event that the parties can't come to an agreement on that issue. And like child support, the obligation of the health care continues until the child either turns 18 or finishes high school, whichever one is later. I wanted to address the spouse's coverage on the health insurance, and this is actually an area where folks in this room might even be able to help me out a little bit. So if you know someone that's getting a divorce and one of the parties is being covered by the other's health insurance, this might be a great opportunity to refer to perhaps an agent in this room that does health insurance, because that other spouse is probably going to need health insurance coverage. Health insurance companies, they do not allow the spouse generally to continue to be covered by a health insurance policy if they are actually getting a divorce. I do tell parties, that's actually one of the biggest reasons parties in Ohio at least get a legal separation instead of a divorce, because if you do get a legal separation, you can continue to be covered under the spouse's health insurance policy. But with a divorce or dissolution, they're not gonna cover it. COBRA does continue. That's probably not going to be a reasonable cost, and certainly we could have a whole speech about that. But so COBRA is still offered, and the spouse can take that advantage of COBRA coverage. But like I said, it's probably more expensive than going out and getting an individual policy, perhaps. So what I tell my clients in a divorce situation, and perhaps you guys can tell me whether this is right or wrong, but I usually tell my client that whether or not they need to report they always need to report the divorce, but when they need to report the divorce generally depends upon the actual policy itself. And I tell folks that if they can wait until the enrollment period, if their policy allows them to wait until the enrollment period to tell them about the divorce, it's usually a good idea, because then the other party gets some perhaps a little extra coverage depending upon when that is. But usually it's a good policy to tell them as soon as that occurs, and that's probably something they would prefer. But I have run into situations, I think, where the folks that they're receiving the policy from, they don't allow them to actually remove the spouse until the renewal period. So